Go ahead.
Hello, everyone. My name is Lisa Honka, and I have a company called Your Key to Senior Living Options. Over the last few months during the pandemic, we've been interviewing experts on different topics related to senior living here in the villages. And today, we're excited to have Ed Soulsby with us. He is an attorney. He's local here in the villages, and he works with Mary Trotter at Trotter in Soulsby. He is an excellent attorney that can talk to us today about Medicaid planning. But before we start, I wanted to give you sort of an update on some of the things that we've got coming your way in the next few months with Your Key to Senior Living Options. We have an event coming up on October 22nd, Sadness versus Depression, Stress versus Anxiety, and we'll be partnering with TLC for that event. We're working with Jackie Coons from the Alzheimer's Family Organization on dementia do's and don'ts, effectively managing difficult symptoms. And that's going to be on October 29th. And then we're going to be working with TLC again on Unleashing the Power of Your Mind. That's November 5th. At 10 o'clock. All of these events are on my website, yourkeytoseniorlivingoptions.com/events. So if anybody wants to sign up for those, they're always listed on the website. And this webinar will also be posted there so that you can share it with your friends, you can review it, you can share it with your family. And in 2021, we're going to have world-renowned expert on dementia, Teepa Snow, and she will be doing 2 presentations for us. Maureen and I and Jackie actually saw her in Tampa 2 years ago, and we were hoping to do a big live event here in the villages just to bring her dementia expertise to the community. But we're going to actually do a Zoom call, which is going to be fantastic, and that's on January 28th and then February 25th. So share that with your friends. It's free for all that sign up. So we're going to start now with Ed Soulsby. Thank you, Ed, for joining us. I know you're a busy guy. You've got a lot of stuff going on. You're helping a lot of families, and we are really blessed to have your expertise here in the villages. I know you've helped lots of families. In fact, your name came up 2 or 3 times this week with families that I am working with who have worked with you as an attorney and then also pre-planning for their loved one who has a very severe diagnosis, and they know at some point they may be looking at Medicaid placement. So thank you again for spending an hour with us and sharing your expertise. So Ed, take it away. Tell us a little bit about you, and then go ahead and give us your presentation.
Sure. So thank you, Lisa and Maureen, for having me today. As Lisa mentioned, my name is Ed Soulsby. I'm with the law firm of Trotter and Soulsby, and my partner is Mary Trotter. Both Mary and I are board certified elder law attorneys in the state of Florida. So there's only about 100 of us throughout the whole state. And you have 2 of them right here in the same office in the villages. So we had to sit for an exam and tell the state of Florida through the bar that we know enough to be experts on it. So that's why we took those tests, and that's why we're both certified. So we're excited about that. Just a little personal information about me. I'm originally from Michigan, but I've been down here now 20, 21 years. So I'm pretty much a Florida resident at this point. And I have a young family. My wife and I have 2 boys, one who's 16 and one who's 11. And so that's exciting and fun, especially when the 16-year-old is now learning to drive. So I want to thank everyone for having us here today, and we're going to start talking a little bit about understanding Florida Medicaid, because it is slightly different from many other states. So anything that you know about what other states do for Medicaid, we have a lot more flexibility in Florida. But first, we're going to focus on one program that is available in Florida for Medicaid, and it's under the Institutional Care Program. This is where we're concerned about a family member who may need skilled nursing care, and we don't want the family to have to pay thousands of dollars each month for that private pay care. So the options are to look and see what the state of Florida will pay for Medicaid. So first, we're going to look at a single person eligibility. Well, what can the person who has no spouse and no other family in place get qualified for Medicaid? Well, they have to have assets less than $2,000 or at $2,000. They can have a home. Their home does not count against them, but the equity in the home cannot exceed $595,000. They can have a life insurance policy or policies as long as the cash value of those policies do not exceed $2,500 in the aggregate. So we've had cases where someone may have more than $2,500, and we have to use techniques to get them down under that number for purposes of qualifying them for Medicaid. You can have a prepaid burial plan of any value, whether it's cremation or an actual burial arrangement, as long as the contract that you've executed for that plan is irrevocable. You can have what's called a burial savings account. Now, don't be misled by that phrase there. It's actually just a traditional savings account, but when we qualify for Medicaid, we indicate to the state that it's actually designated for burial expenses, and we fund it with $2,500. And usually we name beneficiaries on that account because we don't want the state of Florida coming back and saying, hey, give us that $2,500 for the benefits we paid. Now, you're free to have one vehicle of any value that's less than 7 years old. So we've had circumstances where a family has bought a $50,000 Mercedes for the person who's in the nursing home. They're allowed to do it. The car will sit parked in the garage, but they're allowed to have that vehicle. And they may have as many vehicles as they want that are more than 7 years old, but there are some restrictions. So if you happen to have a collectible or an antique, well, then we're going to have to address that vehicle. And unfortunately, the state of Florida is not very generous in terms of how much income you can receive each month. So if your income is less than $2,349 per month on a gross basis, and you meet these other requirements, you can qualify for Medicaid as a single person. Okay, so next slide. Now we're going to talk about the situation where you need someone in a married situation where the spouse needs eligibility for Medicaid. So again, we're looking at the assets of the Medicaid spouse as well as the community spouse or the healthy spouse. So if we're looking to qualify one of them, the applicant, again, can't have more than $2,000 in countable assets, which does not include the home, but the healthy spouse remaining at home cannot have more than $128,640,000 in countable assets to qualify the Medicaid spouse. There's a difference when it comes to the home. As if in a married situation, as long as the healthy spouse remains in the home, you can have unlimited equity in the home. So you could have a $2 million home, and as long as the healthy spouse remains in the home, you can still get qualified for Medicaid. Same thing with life insurance. Again, the remaining numbers are pretty much the same in terms of life insurance, prepaid burial plans, and burial savings accounts, and the automobiles. And the income cap is the same for purposes of the Medicaid applicant. However, the healthy spouse at home is entitled to have a combined community allowance income that's capped at $3,217 a month. Now that's an amount that the healthy spouse has in their own income, plus the amount they get from their Medicaid spouse, plus some shelter costs. So that's what the state of Florida provides for the healthy spouse as well. So they're not all that generous, and that's why we have to go through all these exercises to get someone qualified and put, the spouse and the family in the best position possible. Next slide, please. Oh, I think we jumped one. Did we jump one? Go back. Oh, it looks like they're out of order. Okay. Let me see here. The one I'm looking for, it should say who qualifies for Medicaid, scenario number 1, but does not have the red, does not qualify. Okay, well, let's do this. We'll go to scenario number 2 because I don't have the scenario number 1. So next slide, there we go. So this is a married situation and the husband needs nursing home care. We're looking at assets of $240,000 in equity in the home. They have a $40,000 joint investment account and $1,000 in the joint checking account. The wife has a 2011 Chevrolet, and the husband owns a 2015 Hyundai. His income is $1,600 per month, and the wife receives $800 per month in gross income. So now we need to look and see, based on these numbers, do they qualify for Medicaid? Next slide. Unfortunately, based on these figures right now, they do not qualify for Medicaid because the husband has more than $2,000 in countable assets in his name right now, and they have one too many cars that are younger than 7 years. So what we can do though to get qualified for Medicaid is we could move the $40,000 to the wife, because we're permitted to do that in Florida. That's one of the unique things about Florida Medicaid is many states don't let you make transfers between spouses. Florida does. So we move the $40,000 to the spouse in her name alone. And then we have her sell the 2011 vehicle because she would want the newer vehicle to get around in. So now we've just taken steps to reduce his exposure to having too many assets, and now they can qualify him for Medicaid because he's now under $2,000 and he has all these other assets are exempt. Okay, next slide. Now we have another married situation. Again, husband needs nursing home care. You're going to see that more often than not, that's the husband that actually needs the Medicaid than it is the spouse or the wife. And that can be tricky because more often than not, the husband is the one who's bringing more in income, whether it's pension or Social Security. So we're trying to sort out how much income we can get to the wife. But in this situation, they have a $2.4 million home. The wife has $1.7 million in an IRA. The wife also has $100,000 in savings. She has $10,000 in a checking account. The husband only has $1,500. So here you can see clearly the wife is bringing in the money in this situation. The wife has a 2012 BMW and her husband has a nice 2020 Maserati. Okay, he's bringing in $2,000 per month and she's bringing in $6,500 per month. Next slide, please. Surprisingly, the husband qualifies for Medicaid in this situation because remember, she's going to remain at home while he's in the nursing home, so they can have as much equity in the home. So the 2.4 million is not a problem. The 1.7 million in her IRA, the presumption is she's taking distributions from her IRA at this time. And what the state of Florida says that you can have this large of an IRA as long as you're taking your minimum distributions from it, that IRA does not count against you and you can get still qualified for Medicaid. And then she has 100,000 in savings, 10,000 in a checking. So she's well under that 128,640 number we talked about earlier that the community spouse can have in terms of assets. His 1,500 in checking puts him under 2,000, and she has a vehicle that's older than 7 years old, and he can have a vehicle of any value that's new. And so those vehicles are exempt as well. Now, of course, her income is $6,500 per month. So in this situation, his $2,000 of income, all of that would go to the nursing home. She would not be entitled to any of his income because she makes too much herself. All right, next slide, please. Now we have this single woman who needs nursing home care. She rents an apartment. She has $2,550 in a checking account, does not own a car, and receives $1,100 per month. Let's see if she qualifies for Medicaid. Next slide, please. Unfortunately, she does not because she has more than $2,000 in the checking account. Now, we could easily get her under $2,000. She could pay off some debts. Maybe she needs some dental work. We know how much dental costs are. So we just send her to the dentist and we can easily get her under $2,550 or under $2,000. So those are the scenarios. And it's interesting if you notice that you could have a wealthy family, married couple, and if the assets are titled or deemed an exempt asset, you can get the spouse who needs Medicaid pretty much qualified for Medicaid. But then we have this single person here, unfortunately, just because they're over $2,000, they don't qualify. So if you look at it, there's usually concern there that there's I guess I don't want to say a bias, but it's if you're more wealthy and there's options available to you. Where if you're more poor, then we have to do things to get you under that $2,000, and it can be difficult sometimes. Next slide, please. Now, there is another program for Medicaid. It's called the Medicaid Home Community-Based Program, and it's a waiver program, and it's based on the same asset and income thresholds that we need to qualify for someone. But this is where we don't want them in the nursing home. Maybe they can still do some things for themselves at home, whether or at assisted living. But again, they still have to have the asset and income thresholds met. There are some activities of daily living or their ADLs that maybe they can't perform and they do need a level of care. And so Medicaid will pay for that level of care. But unfortunately, in this situation, the person who is receiving the care and gets on Medicaid, they're still going to have to be responsible for the room and board rate. Medicaid's not going to pay for that in the waiver program. So if your husband or your wife is in assisted living and you want to qualify for the waiver program, just keep in mind that the room and board rate will still need to be covered. Next slide, please. Now we're going to talk about Medicaid planning strategies. What do we do to get someone in a position to be qualified? Next slide. So Medicaid planning can be as simple as turning non-exempt assets into exempt assets. Next slide. So we're talking about a qualified income trust here. This is when someone's income on a gross monthly basis is too high. So if you remember, we had that one example in the married situation where the wife actually was making $6,500 a month in gross income, and she was looking to get Medicaid for her husband. Well, let's turn that around. Let's say that she needed the Medicaid. Now, what do we do with that income over the 2,349 number that we talked about at the beginning? Well, we have to create what's called a qualified income trust to move that income that she receives in excess of that 2349 number into that trust each month, so that then it's qualified, and then we can use those funds to pay the nursing home, or if it's the waiver program, on the needs of care for the person who's on the program. So don't worry if you make too much money per month, we can still get that person qualified by use of what's called a qualified income trust or a Miller trust. Next slide, please. Now, there are some strategies that we have to implement, and it's all dependent on whether you're married or you're single, the timing of it. You know, we usually recommend that if someone is diagnosed with onset dementia, Parkinson's, or Alzheimer's, as soon as that diagnosis is made, it's better to get in to do planning, because, you know, we have, if we don't think they're going to need Medicaid for 5 years, then that gives us the opportunity to do some good planning to make sure that we can move assets around, especially if they have a lot of assets that are considered non-exempt or countable. And then the health of the person. Medicaid always wants to make sure that whoever needs the care, that they're actually meeting those level of care needs. And that's looking at what their activities of daily living are in terms of what they can perform without substantial assistance. And that means whether they can bathe on their own, prepare meals for themselves, take their medication on their own, how mobile are they, are there any toileting issues? So we look at those, and if they fail a majority of those because they need assistance, then Medicaid will say, okay, you're at a threshold of where we feel that you meet the needs at a level of care basis. Next slide, please. Now, the more time that planning is done before Medicaid is required, the easier it is to protect assets. However, there are many strategies to protect assets even after a person is already in a nursing home. We've had many situations where someone calls up and says, mom or dad is in rehab right now. We're counting down the days to where Medicare will no longer cover the rehab. What can we do to get them qualified as soon as possible when we move them to a skilled nursing facility? Next slide, please. Now, some of the strategies that we're going to talk about going forward here is what's called spend down. We can shelter money in a residence. We can do what's called personal services contracts, make transfers to an adult disabled child. We can deal with annuities, and that's a special topic in and of itself when it comes to Medicaid. We can do what's called spousal refusal in a married situation. We'll address divorce. We can do jointly owned real estate and income producing property. And we'll talk about the Florida Partnership Program as well as asset protection trusts. Next slide, please. Now, when it comes to spending down, there are a lot of opportunities available to us. We can buy a brand new car of any value. So if you remember, I mentioned about the family who bought the $50,000 Mercedes and then they just parked it. That's a permissible option available. We can do prepaid burial. You can make home improvements or repairs, whether you need a new roof, a new air conditioning system, making the house more amenable for disabled people. You can do a lot of things to take countable assets and put them into an exempt asset like your home. You can pay off debts. Well, we need to make sure that the debts that are being paid off are actually valid and documented. We don't want someone saying, well, it's a debt I paid off for one of my children. That's going to be a problem for Medicaid if you paid off someone else's debts. Or you can shop till you drop. You can buy anything that will make your stay in the nursing home more comfortable, whether it's buying a nice big screen TV because your vision is bad and you need to see the TV as big as it needs to be. We can do a lot of that. And of course, attorney's fees. Yes, unfortunately, we would have to be paid for any work we do as part of the medication application process and the tools used. Next slide. Now, we can shelter money in a residence. So if you're single, we can have you buy a homestead property and it can have equity up to $595,000. But there is a risk that at some point, if you are in the nursing home and the value of your home increases, you could go over that cap. Now that 595 number does adjust, I think, annually. So we work based on what Medicaid provides from any given year on that number. If you're married, you can have any amount in a residence as long as the healthy spouse or a disabled child continue to live at home. But there is that risk out there that if the healthy spouse or the adult disabled child is no longer living at the home because they predeceased the Medicaid applicant, then there's that risk of the home no longer being protected in terms of the equity. Next slide, please. We can do personal services contracts. Now, this is where we have usually a family member or someone who's really close to the Medicaid applicant, where they would get paid for their caregiver services. And usually we can actually maximize this type of option when the person who's providing the services is a resident of Florida and is near the Medicaid applicant. And in the personal services contract allows us to make a lump sum payment to the caregiver that they have to report for income in the year of receipt and then pay the income taxes on it. But the idea is that it's a way of moving assets that are otherwise considered countable for the Medicaid applicant and moving them to this caregiver so as to get them qualified for Medicaid. Next slide, please. We can make transfers to an adult disabled child. We can actually give straight transfers of assets to an adult disabled child because you are taking steps to still provide for that child. And if they're living at home, we've seen it where this adult disabled child living at home with a Medicaid applicant, and we just transfer the home and we're permitted to do it. And so those are some of the options available to. Now we can also do what's called a sole beneficiary trust that can be used so the adult disabled child still qualifies for Medicaid themselves if they're receiving Medicaid. Next slide, please. Now annuities. As I mentioned earlier, annuities are a whole topic in and of themselves because Medicaid is very clear when it comes to annuities. You have to meet specific requirements. And it has to be an immediate and level payout, and there can be no transfers for less than fair market value. So we have to meet the following requirements. The annuity must be irrevocable. It cannot be assignable. You have to base the payout on the life expectancy under Social Security Administration tables. So you can't just say for life, it's just based on what the tables are. And the payments have to be equal, so same amount every month. So no balloon or deferred payments. And there are specific beneficiary requirements. Next slide, please. And with community spouse annuities, we must use the Social Security Administration life expectancy tables and meet specific beneficiary requirements. Next slide, please. Now, when it comes to the person who's actually getting the Medicaid, the state must be named the beneficiary if we're dealing with a single person. And if the institutionalized person has a community spouse or a minor or disabled child, then the state is put into the second position, because the idea here is that the state of Florida, if they're providing benefits to you for your nursing home care, then they want to be named as the beneficiary on any proceeds remaining in that annuity. And then if it's a community spouse with respect to beneficiary requirements, you must name the state in the first position since you're already receiving those benefits unless there is a minor or disabled child. Next slide, please. And then married applicants and annuities, we continue here. Florida's adopted the rule that only requires state repayment for medical services provided to the annuitant. Next slide. Spousal refusal. Now, this is an option that we've used over the years where one spouse, basically the healthy spouse, says, no, I'm not paying for the care or for the services that the Medicaid spouse needs. And so basically the Medicaid spouse signs over all of their right of support to the state of Florida. So under spousal refusal, we had an instance a few years ago where we had a married couple in their 80s, and the wife suffered a stroke. And fortunately, she recovered physically, but on the mental side, she was trapped in her 20s. So they had about $1.5 million in assets, and we were able to take steps of working with the husband to move assets that were in her name or jointly with him all to him. She was only receiving about $600 a month in Social Security income. So the moment we moved everything to him, we just now have made her look poor from an asset perspective because we got her under $2,000, and only her income would go to the nursing home. He didn't need it. He had plenty of his own. So he executed the spousal refusal option for purposes of getting his wife qualified for Medicaid. So he no longer had to pay thousands of dollars each month. If, privately, he had the state of Florida pay for her care. Next slide, please. Divorce. Now, many states outside of Florida, this is your only option. In Florida, that is not necessary, as we have a lot of better planning tools available to us to qualify the Medicaid spouse. We've heard stories on the Northeast of a married couple married 60 plus years, and one of them, becomes ill and needs skilled nursing care. And unfortunately, their only option is to get divorced to get the care for the ill spouse. So in Florida, do not worry. Divorce is not necessary to get qualified for Medicaid in the married situation. Next slide, please. Now, one other option or strategy we can use is having jointly owned real estate or income producing property. So with jointly owned real estate, let's say that you owned a piece of property jointly with one of your children or a friend. The state of Florida says for Medicaid purposes, you're permitted to have that jointly owned real estate, and it will be considered an exempt asset because we can't force the other owner of the property to sell the property just to get you qualified. So that's what's permissible. And then you can have what's called income producing property, rental property. So you could buy a rental and have that income come in, and then we can structure it in a way to protect that rental property down the road. Next slide, please. Now there's a program when it comes to long-term care policies. It's called the Florida Partnership Program. And if you have a long-term care insurance policy that pays a minimum benefit for a period of 3 years, then the state of Florida says, well, thank you. You've delayed the need for us to pay any benefits for you on your behalf. So we'll allow you to protect assets in addition to the $2,000 that they said you can only have, but for whatever the amount of benefits you received or paid out over that 3 years from the long-term care policy. So if the long-term care policy paid benefits of $300,000 over the 3-year period, the state of Florida says we'll give you $300,000 plus the $2,000 you're allowed to have, for a total of $302,000 that you can protect otherwise countable assets. So provide some more flexibility if needed. Next slide, please. Now we're going to talk a little bit about Medicaid Asset Protection Trusts, or MAPTs. Now this is what we usually use when we're doing some advanced planning ahead of time, because we've learned that someone's been diagnosed with onset dementia or Parkinson's or something like that. And we want to be able to take steps to move assets of substantial value in a way that will allow that person to ultimately get approved for Medicaid down the road. Now, you may have heard what's called a look-back period. And Medicaid says if you've made transfers to third parties like children or friends within 5 years of applying for Medicaid, they're going to disqualify or presume those transfers are disqualifying because they believe you did it for purposes of applying for Medicaid. But if it's more than 5 years from the time you need Medicaid, then those transfers will be ignored and the assets that you've transferred will be exempt. So in this situation, we can create what's called this Medicaid Asset Protection Trust. When the assets are transferred to this trust, they are immediately protected from all your general creditors because it's an irrevocable trust. You've given up control. And after 5 years, the assets in the trust are exempt from Medicaid. Next slide, please. Now, it's a self-settled trust. It's not a self-settled trust because it doesn't work because the grantor is also the beneficiary of both the income and principal. So with a Medicaid Asset Protection Trust, only you as the grantor creating the trust are entitled to the income only. You can no longer have any control over the actual asset you've transferred because it'll be in the hands of a third-party trustee. It could be a family member or someone else, but you can no longer have control over that asset you've transferred. Next slide, please. The MAPT is an irrevocable trust that allows you, the grantor, to receive all the income from the assets, including the right to live in any real property, but there can be absolutely no direct access to principal. If either the grantor or his or her spouse has direct access to the principal, the assets in the trust would be deemed countable for Medicaid eligibility purposes and would be completely available to almost all other creditors in most states. So the idea is we want to make sure that it's done right, that you're entitled to the income, but you have no direct access over the assets in the trust. And that's what's key, is making sure there's no direct access to the principal. Now, let's say you create this trust and you're getting the income and you've named one of your children as the trustees who are in charge of the trust. And in fact, your children could be named as what are called the principal beneficiaries during your lifetime. So that if any distributions from the trust were to occur, they can be made to your children. And if you need more money than what the income's providing, there are options available to you to make sure you have additional expenses covered if the trust needs to do it through the use of principal distributions to your children. Next slide, please. And there are two ways that the grantor can be given indirect access to the trust principal. The first way is that the trust is written so that the trustee has the right to make distributions of principal to the trust beneficiaries, who are typically the adult children of the grantor. If a trustee distributes principal to a trust beneficiary, that beneficiary can then voluntarily return some of the principal to the grantor. And the other possible way for the grantor to get at their trust principal is for the trust to be revoked. Next slide, please. The term irrevocable means only one thing, that it cannot be unilaterally revoked by you, the grantor. Although it is irrevocable and can't be revoked unilaterally under common law and under the Uniform Trust Code, which has been enacted in 21 jurisdictions, and the Florida Trust Code, a non-charitable irrevocable trust can be modified, revoked, or partially revoked upon the consent of the trustee and all trust beneficiaries. Next slide, please. So again, there are two ways that the grantor can possibly gain indirect access to the trust principal, either by distributing it to the beneficiaries, who then turn around and give it back to the grantor, or by revoking the trust with the agreement of all the beneficiaries. Next slide, please. Now, there are advantages of a trust over giving away assets. If you give away assets, you no longer retain control. You've given it away to someone, and if you give it to a child, they can lose your assets. But if you put it in a trust, like a Medicaid Asset Protection Trust, you still have a level of control, and the children cannot lose your assets, because with this type of trust, even though your child may be the trustee and the beneficiaries, there's a concept that we use. It's called a trust protector. That is someone who's looking out for your best interests. So that if the trustee is deciding, you know what, I'm going to make distributions to myself as a beneficiary, which will reduce your income stream, the trust protector can take steps to remove that trustee and make sure there's one in there doing the job. So the idea is we still want you to have some interest in it, and that your children just can't go out and lose your assets. So both spouses' children will be able to receive an inheritance. That's the idea. You're taking steps to protect assets that would otherwise be countable, but also hopefully providing for your children down the road to receive whatever's remaining in this trust. Next slide. Now, the main type of assets that can be funded in the Medicaid Asset Protection Trust are your primary residence, any secondary residence, any non-mortgage investment real estate, any non-qualified financial investment. So we're not talking about retirement accounts like IRAs or 401ks. We're talking about straightforward stocks and bonds, mutual funds, those type of brokerage accounts. Ordinary bank accounts can be in this type of trust. And you can have life insurance as well. Next slide. The main types of assets that shouldn't be transferred into the MAPT are qualified retirement plans and your primary checking account. We don't want your checking account because that's where your income's coming into. We want that outside so you still have access to those funds directly. And we typically don't put annuities into the trust either, but it really depends on the type of annuity, because there could be taxable consequences of transferring an annuity into an irrevocable trust. Next slide, please. And a Medicaid Asset Protection Trust may also be used to qualify for VA benefits, but the grantor cannot be the trustee. Next slide, please. That's our presentation today. If you'd like to talk to an elder law attorney, if you think Medicaid may be an option for you, by all means, feel free to give us a call and reach out to our office. And of course, all our consultations are complimentary, and we'll be glad to speak with you and answer any questions that you may have about Medicaid or any other topics that you want to discuss as it relates to your estate planning. Are there any questions that we have out there from anyone that we talked about?
I've got a couple of questions. Let me see if I can there's my video. Okay, good. So I can see your face. All right, and you can see my face. Wow, that was a lot of information. Yes. And there's a lot to think about, right? Who are the children? Are they honorable, and can they really navigate for you if you protect your assets? Absolutely. And then also one of the questions I had, this trust protector, is that ever an attorney? Is that ever someone like you?
It is. It is. Many times the client will name us or someone they have great faith, trust, and confidence in, like an accountant or a close family member, or not even family member, but a friend, somebody that they believe will look out for their best interests. And in the years that I've served as a trust protector, whether it's in this type of trust or other type of situations, I always tell the client, my goal is to never come out of the shadows and see the light of day. I never want to be called to say, hey, this trustee's acting badly, we need to remove them. And so far, knock on wood, no one's called and said someone's acting badly. But that's why they're there, to make sure that the interests of the grantor are being addressed. Because it can be very easy for the trustee who's a child to say, well, I am the principal beneficiary of this trust during my mom's lifetime. I can take assets out. But by doing that, you're reducing the income stream to your mom, because that's the whole point, to give them some income over that 5 years while that trust is still waiting to cure and be protected from Medicaid.
Is it often that you might have two people in that position, a brother and a sister, or two from two different, marriages, in order to kind of look over each other, or is it usually a one person?
No, it can be a combination of children involved. If it's say it's a second marriage and you want one child from this side and the other one, absolutely, they can act together.
Okay, I have another question. So if someone put their home into a trust to protect it, right? And then years later, right, that you're worried about the husband who needs to perhaps go to a long-term care facility, nursing home, memory care, and the wife suddenly realizes, I don't have liquid assets to pay for me to go to an independent living. All my assets were really tied up in that home. Do you have the ability to sell the house and now the assets from the sale of that house go directly into that trust?
So are you talking about, Lisa, the Medicaid Asset Protection Trust or just a run-of-the-mill revocable trust?
Well, whatever you would have put them in to begin with.
Well, so if we had met with a couple and we were just doing basic foundational estate planning and the
Yep.
use of a revocable living trust, more often than not, the married couple will put their home into the trust just for purposes of avoiding probate
Right.
down the road. But if we come to learn that one of them needs Medicaid and
Yep.
we take steps then to say, okay, more, especially if they're married and they have all the same children,
Yep.
then what we do is we would update the planning to move the home into the name of the healthy spouse so that they
Yep.
have the flexibility down the road. And then once the Medicaid spouse gets approved, if the healthy spouse ever needs to sell the home, she can keep the proceeds or, downgrade to a smaller house type of thing.
Yep.
But it gives that flexibility.
Yeah, that's what I have a family right now that I'm working through that because they have no liquid assets. All assets are tied in the home, and she doesn't have any flexibility to downsize. And so, so my question and her concern was, would she lose the house if she had put it in the trust and then couldn't control it? But she would just tell the person that was sort of navigating for her that she wanted now to sell it, and they would help her with that.
Yes, absolutely. We can do that. Yeah. If they had put it in a Medicaid Asset Protection Trust, and in Florida, it's very rare that we would put a homestead into a Medicaid Asset Protection Trust because it's already a protected asset for Medicaid in Florida. We've seen a lot of New York residents who moved to Florida who have put their primary residence up there into a Medicaid type trust because in New York, they don't have the same protections that we have here in Florida. So if it's in a revocable trust, absolutely, we can take steps to still preserve the flexibility for the healthy spouse. If they do sell it, we still have to keep in mind about if are they getting any of the income of their Medicaid spouse, and are they still under that threshold of $128,640 as well?
Right. And then also that VA benefit, if they were to go down that path, the VA benefit plus their monthly income sometimes over qualifies them. Are you able to go back to the VA and say, I don't want all 1,800 because I have 1,000 already in my monthly income? Are you able to go back and say, I don't want the full benefit because it would throw me out of the Medicaid?
No, so that's the thing with VA and Medicaid. They sound like they would work together hand in hand, but they don't, unfortunately. What VA says you can do is different from what Medicaid says. So with VA benefits, it's more often not that the spouse or the care that's being needed, they're getting what's called aid and attendance benefits.
Yes.
It's a source of monthly income coming in to help offset the care expenses. And under the current rules, they actually changed in the last 3-4 years. VA has now said you can't make transfers within 3 years of qualifying for VA benefits, and you still have to be under those thresholds of $128,640, and yet the net annual income has to be, I think, $26,000 or less, and that's where they make up that difference. But if you're getting VA benefits and you're concerned about additional income coming in, there will be an offset. They more often than not will reduce the benefit. My understanding is if they see that your income is going up. Now, and as long as you're still under that threshold of annual net income of $26,000 a year, that's fine, but they will adjust it based on what actual income you're bringing.
Yeah, great. Okay, I have a couple more questions. So if I get on Medicaid, would I lose my house?
No, as long as you remain under the equity cap, if it's a single person or $595,000, and if it's a marriage situation, the spouse continues to remain in the home.
Perfect. And can I make gifts to people to reduce my assets?
You cannot make gifts to family or friends or other third parties. Even Medicaid has said if tithing to your church is considered a disqualifying transfer. But keep in mind, it's a rebuttable presumption. They're viewing it as that they presume that you've made the gift in contemplation for Medicaid. So I've had situations where, in a married situation with spousal refusal, where over the years for their estate planning, they've made annual gifts to their children. Now, Medicaid's going to say, well, wait a minute, either those gifts come back or, the spouse that needs it doesn't get qualified. Well, in that situation, even if the gifts came back, we were using spousal refusal. So those gifts that would come back, we would just move to the healthy spouse and we would just end up qualifying the Medicaid spouse anyways. But yes, you can't make gifts to anyone except for a spouse to qualify for Medicaid.
And then the last question, are IRAs and 401ks treated the same?
Yes, for purposes of retirement plans like those type of accounts, as long as you're taking minimum distributions from the IRA or the 401k to qualify for Medicaid, the principal of those accounts will be exempt and won't be counted against you for qualifying for Medicaid.
Wow, lots and lots of information. Does anybody have any questions? That was a lot of information. Was this helpful to everybody? Yes, we learned a lot. I have a couple of comments over here, Ed. I don't know if you can see them, but people said, I'm going to make an appointment. So that's good. So that's
great.
good,
Perfect.
right?
I'll be glad to speak with them.
Right, because this is hard stuff. It's if you're planning for your parents who live in the area or parents that are coming down that might be eventually Florida residents, or if suddenly you've inherited an in-law, right, and you're trying to figure out what to do. So yeah, this is tough stuff, and we appreciate your expertise.
Oh, you're very welcome. Thank you for having me today. I truly appreciate it. And yeah, if anyone has any questions, by all means, feel free to reach out.
Does anybody have any questions? Was this helpful, everybody? Yeah, it's a lot to think about. And again, it's really important when someone's diagnosed to really start thinking about the future, about the one that's left behind or could be left behind. And how do you really look at the financial picture and match that up with legally, how do we protect the one that's left behind or the one that may need care if it becomes catastrophic, right? Because at that point, you really have to look with eyes wide open at all different possible scenarios, right? And that's when an expert like you comes in to really help handhold, guide them, talk to the adult children, bring all the parties in and kind of say, of all the things that I'm looking at, these are some of the options for scenario 1, 2, and 3, right?
Of course, absolutely. Yeah, and each scenario is unique. Each family's different in terms of what they're dealing with, whether it's a single or a married situation, whether they have a lot of exempt assets. We have, people coming in, well, I have my home, a car, and a retirement account, and some money in the bank. Well, that's pretty straightforward, but if they come to us and says, well, we have these annuities and we have rental property and we have a lot of other things, then we have to do some planning and steps. So as I mentioned earlier, if there is a diagnosis of some type of onset condition, the sooner the better to start the planning, then that would be the best outcome. Not to say that if you came to us, a month ago and said, I need a nursing home in November, then we can do that. We've done it before. It just means we're moving at a faster pace. To get that person qualified for Medicaid. But we do like it better when we're having a lot more time to plan.
Right, right. And some of the other things I think too is, when you're diagnosed with, let's say, Parkinson's or Alzheimer's, right, you're kind of thrown into, oh my gosh, I'm worrying about my diagnosis and my future. And sometimes it's hard for that spouse or that adult child to say, well, there's this elephant in the room. We kind of got a plan. I'm not saying, we want to take everything away from you, but what we're trying to do is protect the one that might be left behind, right? And that's a really tough emotional conversation when you've just been handed the big blow, right? And almost kind of thinking, with you being the trusted one, how do you gently tread on those emotions, right? And then start to talk about, asset protection and pulling assets away from the one that's has a new diagnosis. That's tough stuff.
It is because, even the one who's been diagnosed, they want to be involved in the conversation. They don't want to be looked at like I'm, not in the room anymore. Yeah, like, you're just talking around me, past me. No, they want to be involved. And as long as they have an understanding of what we're trying to accomplish, because yes, as you said, Lisa, we're not only trying to preserve assets for both of them and get one qualified, but when the one who's qualified for Medicaid does pass away, now we still have the healthy spouse who's going to have to need those assets. And so the idea is that we're doing it for both of them. We're not just doing it for one of them.
Yeah, it's really a gift, I think. You know, when you really talk about what is life insurance, what is planning, you know, even looking at getting, you know, your burial things out of the way. Today's dollar is better spent than, you know, next year's dollar, right? But even, you know, again, coming down to Florida, when you come down, have you review legal papers, right, from other states. That's where we start. And then really talking about how's your health history year after year, you know, just checking in. How are things going? Any new diagnosis? Is there anything that we need to adjust? Are the children still involved, right? Or are the children not trustworthy, or they passed away? And we really do need to, again, look at your legal documents every few years to make sure that this is current and this is still your wishes, right?
And we always recommend if you're moving to Florida or have recently moved to Florida, by all means, see an attorney to review any existing documents you have done from your prior state, or to actually get documents in place. There's nothing worse for me as an attorney when I have someone come in, a daughter, a son, or even a spouse, and says, we've done no planning, and now my husband or my wife is in rehab and they're cognitively unable to understand what's going on. And so in order to do that, that creates more legal mechanisms that we have to go through involving the court system, for example, like a guardianship. So yeah, the sooner the better to have your documents reviewed. And if you do have that onset diagnosis, definitely get in to speak with someone so that we can review those documents and make sure everything's in place and any planning that needs to be addressed.
Yeah, and you know, here down in Florida, we have a lot of new marriages, right? So even ahead of time, kind of talking through new marriages and new legal documents, right? Or even people who are profoundly alone, their spouse passed away, they don't have adult children, or the adult children have passed away, or they're estranged. And then, you know, just making sure that really their wishes for the end of life are carried out, and who can help navigate for them if there's a catastrophic event. And that's where you come in to really figure out who that's going to be and how to make sure that they're always safe.
Yeah, because that's my job as an elder law attorney, same as Mary's, is that, yeah, we would like to be able to pass on assets to the next generation. But job number one for us is to make sure you have the resources available to you for the rest of your life for your care.
Right, right. Well, thanks for your expertise. I'm sure you're going to be getting a lot of calls, and this will be posted. So if anybody wants to share it with family, you can send the link off to family in other states, other areas, or friends that might benefit from talking to Ed. His contact information will be on our website. So thank you again, Ed, for your time. Say hello to Mary for us.
I will. Thank you, Lisa and Maureen, for having us, and everyone in attendance. Thank you for participating.
Yeah, stay safe. All right, we'll talk soon.
Take care. Bye-bye.
Bye.